Hello and welcome to today's presentation. 3 things you must know about the seller's right to keep the buyer's deposit. I'm Jim Urquhart. Before we get started, there's a couple things you need to know since this video or presentation can be viewed all over the world in many countries. You need to know that it is relevant in the state of California, USA. It involves transactions there, particularly residential real estate transactions, 1 to 4 units, which is the typical home or condo sale. That's if you're going to buy a residence in California, this is what you're going to be doing. Normally 1 unit, which is your typical home or condo sale. And this was recorded on May 1st, 2014. Couple things about me since you're going to be listening to me for the next 10 minutes or so. Again, I'm James Urquhart. James Urquhart III is my full name. I'm a realtor, which means I'm a member of the National Association of Realtors and the California Association of Realtors, as well as the local Board of Realtors. I am a licensed California real estate broker. I am also a licensed California attorney at law. With respect to real estate, I am a full-time real estate broker associate. I became first licensed as a real estate broker in 1978. My real estate specialization is residential real estate in the Coachella Valley, California, USA. And that includes cities like Palm Springs, Palm Desert, La Quinta, Indio, and so forth. And we are proudly affiliated with our broker, Tarbell Realtors. I am also a full-time attorney at law. My specialty in my law practice is tax audit defense, tax litigation, and trials. And I first became an attorney in 1977. Just a little bit of a notice that you need to know with respect to real estate transactions. I'll be acting as your real estate agent, but not as your attorney. I can't act as your real estate agent and your attorney at the same time. That would be a conflict. So in real estate transactions, I'll be acting as a real estate agent, not as an attorney at law. So let me set the stage before we get any further. With respect to setting the stage, let's assume we have a seller that's accepted a $500,000 offer from the buyer. So we've got $500,000 accepted to purchase a home in California. The buyer puts down what is typical, a 3% or $15,000 deposit. 3% of $500,000 is $15,000. It could be more, it could be less, but typical in California is 3%. And it's in escrow. So everything's going fine. Offer accepted, 3% put in escrow. Escrow is open. We're chugging along just fine. And then, after the buyer releases all contingencies in writing, the buyer changes his mind for no valid reason. The buyer wants a different property. The seller, of course, is furious under these set of facts. Further setting the stage, we need to know about the RPA, the Residential Purchase Agreement. That's the way we make offers in California. Buyers make offers using this form. The California Residential Purchase Agreement and Joint Escrow Instructions. We refer to it as the RPA, the CAR form, California Association of Realtors form RPA. Well, in the RPA is a paragraph 25 on liquidated damages. It must be initialed by the buyer and seller, but most of the time it is initialed by the buyer and sellers. Most of the time this paragraph 25 liquidated damages clause is in play. It is part of the contract. So setting the stage, you need to know that the liquidated damage clause states if a buyer fails to complete this purchase because of the buyer's default, we've just stipulated that. That's the stage that we set. And that's a big stipulation, by the way. We don't normally know for sure whether the buyer's in default or not, but for purposes of this presentation, we're assuming the buyer is in default. If so, the seller shall retain as liquidated damages the deposit actually paid. How much was paid in this case? $15,000 or 3%. So the seller gets to retain that. That's the deposit actually paid and in escrow. If the property is a dwelling with no more than 4 units, which a normal home or condo is, one of which the buyer intends to occupy, which they do, then the amount retained shall be no more than 3% of the purchase price. So your liquidated damage clause allows the seller to keep no more than 3%. Well, 3% deposit standard anyway, so this normally does not limit the amount the seller can retain because 3% deposit is quite normal. Any excess shall be returned to the buyer. Obviously, if the buyer put in 5%, you're only entitled to 3%. You have to give the 2% back. Here's the big important part. Release of funds will require mutual signed release instructions from both buyer and seller, judicial decision or arbitration award. At the time of an increased deposit, there shall be a separate liquidated damage provision signed if there is any increase in the deposit. It's not that standard. So now we have the stage set, and we know about the liquidated damage clause, paragraph 25. Let's move on to the 3 things you need to know. Here are the 3 things you must know about the seller's right to keep the buyer's deposit. 1. Escrow will not release the buyer's deposit to the seller unless the buyer releases it in writing, or there's an arbitration award or a court order. Next thing you need to know. Under the California Civil Code, the buyer may be liable for a civil penalty if he won't release the funds and there's no good faith dispute that the seller is entitled to those funds because of the buyer's breach. 3. The seller can sue in small claims court for an order getting the deposit from the buyer, also cancellation of the contract. The mediation and arbitration parts of the contract, that's an exception. There's a small claims court exception. So I went through those quickly. Let's cover them one by one in a little more detail. The first thing you need to know about the seller's right to keep the deposit is escrow will not release the buyer's deposit to the seller just because you're asking for it. You call or email escrow, say the buyer is clearly in default, please give me the money. Escrow is going to say, nope, we need the buyer to sign a release releasing the funds to you, and the form we use in California is the CAR form CC, cancellation of contract, release of deposit, and joint escrow instructions, form CC. So unless you can get the buyer to sign that, escrow is not going to release the funds to you. So you're left with basically litigation now, getting an arbitration award or a judicial decision if you are hell-bent on keeping that buyer's deposit. You've got the right to, but this is what you have to do to get it. Have escrow release it to you. The buyer's going to have to release it to you with a signed form CC. If not, you're going to need a court order, either an arbitration award or a judicial decision, or escrow's not giving you those funds. Here's the CAR form CC I was just talking about. If you have a cooperative buyer that knows the buyer is in breach and knows that there's no good faith dispute over the disposition of the deposit, then the buyer will go ahead and sign a CC. The buyer will cancel the contract. Buyer will sign release of deposit 2B. The buyer authorizes release of the funds to the seller. What do you think the chances are of a buyer signing that for you? Very slim. So just be aware the form is there. If the buyer cooperates and signs it, escrow is going to release the funds to you forthwith. If the buyer doesn't sign it, you're left with other options, arbitration award or judicial award. The second thing you need to know is that there's a California Civil Code section 1057.3 that provides for a penalty of up to $1,000 against the party, either party, that refuses to release, provided there's no good faith dispute as to who's entitled to the money. The thing you need to know about this Civil Code section is it cuts both ways. There is a penalty, a $1,000 penalty, up to $1,000, but it could be against the buyer or the seller, whichever is holding up the release of the funds when there's no good faith dispute. The next thing you need to know is the maximum penalty is $1,000 under 1057B2. That's not much of a threat these days because you're dealing with a $500,000 transaction or more. $1,000 penalty. It's not that scary to the buyer. The big thing in my view is in this code section is the winner can get attorney's fees, which can far exceed the $1,000. That's 1057B3. So really, in my view, as an attorney, the $1,000 penalty, that's not the kicker here. If you're holding up that deposit and there really is no good faith dispute as to who's entitled to it, and you force the other party to sue you, hire an attorney and sue you, you can be liable for attorney's fees, which can far exceed the $1,000. Here is code section 1057.3, all of it. I don't expect you to be able to read this. I just want to show it to you. There's a lot going on here. It's not that simple. Recall that 1057.3 doesn't even apply unless there's no good faith dispute. Is the buyer going to agree with you that there's no good faith dispute? No, the buyer's probably going to say there is a dispute. 1057 doesn't even apply at all because of reason A, B, C, etc. Here's the part of 1057.3 which I think is, in my view, the most important part. Any buyer or seller who fails to execute any document required by the escrow holder to release the funds, and you got 30 days to do that, can be liable for reasonable attorney's fees incurred in any action to enforce this section. That can be far, far in excess of the $1,000. Third thing you need to know about the seller's right to keep the deposit is that you can go to small claims court. Small claims court is excluded from the mediation and arbitration terms in the offer form, the CAR form RPA. Most of the time the arbitration paragraph is initialed. Most of the time it's applicable. But when there's a small claims action, there's an exclusion. 26C1, paragraph 26C1 has an exclusion. And here is that exclusion. RPA paragraph 26C1 has a small claims exclusion. The following matters are excluded from mediation and arbitration. Specifically, any matter that is within the jurisdiction of the probate court, small claims court, or bankruptcy court is excluded from the mediation and arbitration provisions. So you don't have to go there first. You can go straight to small claims court. Little bit on small claims court, because really if you're a seller insisting that you want all or part of that deposit, your only practical alternative is to go to small claims court unless the buyer will release it to you in writing. In general, the maximum claim is $10,000 for an individual plaintiff in small claims court. So what do we have here? We have a deposit in this case of $15,000. Well, $15,000 is $5,000 more than the $10,000 jurisdiction of the small claims court. So if you go to small claims court and win, you're only going to get an award of the $10,000, and the extra $5,000 that's in escrow, the courts can't award that to you. It's outside of their jurisdiction, so it's going to go back to the buyer. The plaintiff can't appeal a small claims award, but the defendant can. So even though you go to small claims court, you're a seller, you go to small claims court, you get the award of up to $10,000, the defendant can appeal and tie you up in court for months and years, actually, unfortunately. There are no attorneys in small claims court. It is small claims court, so it's going to be a fast remedy for you, assuming that you win and the defendant doesn't appeal. Also, just a legal tip for you. When you file your small claims action, make sure you serve the escrow company because they're the stakeholder. They've got the money. So any court order, you want the court order subject to a party that's been served. That's escrow. And in court, ask for an order to release the funds, ask for an order to cancel the contract, and ask for an order to cancel the escrow. Does that sound familiar? That's what the Form CC does. So if the buyer's not going to sign that Form CC, make sure you ask the court to give you that in their order. So there you have it. There's the 3 things you need to know. Thank you so much for listening. By the way, that's my son, James Urquhart. We are a team. We are the James team. We are a father and son team. Thank you so much for listening. Hope to see you again soon. Bye-bye.